Section B, remedies for externalities. In property law, a harmful externality is called a nuisance. Remember that our discussion of remedies for nuisance in Chapter 4 distinguished between injunctions and damages, and that the relative efficiency of these remedies has a lot to do with the public-private distinction. If the nuisance is private, few parties are affected by it, and as a result, the costs of bargaining together are low. When bargaining costs are low, the parties will ordinarily reach a cooperative agreement and do what is efficient. Consequently, in those circumstances, the choice of remedies makes little difference to the efficiency of the bargaining outcome. The traditional property law remedy, injunctive relief, is attractive under these circumstances because the court need not undertake the difficult job of computing damages. If one views an injunction as always and forever prohibiting the offensive activity, then its inflexibility is costly. However, if one views an injunction as an instruction to the parties to resolve their dispute through voluntary exchange, then it is an attractive remedy for private nuisances. In contrast, trying to correct a harmful externality of the public bad type by bargaining would involve the cooperation of all affected parties. Bargaining fails in these circumstances because it requires the cooperation of too many people. The law refers to a harmful externality of the public type as a public nuisance. Our analysis suggests that damages will be a more efficient remedy for a public nuisance than an injunction would be. To apply this prescription for choosing between injunctions and damages, the court has to examine the number of people affected by the externality. However, the court does not have to perform a cost-benefit analysis comparing injunctions and damages. Cost-benefit analysis requires more information than courts typically possess. So, legal rules whose application requires a cost-benefit analysis should be avoided. When compensatory damages are perfect, they restore the victim to the same utility curve as he or she would have enjoyed without the harm. Compensatory damages can be temporary or permanent. With temporary damages, the plaintiff receives compensation for the harms the defendant has inflicted on him or her in the past. If harms continue in the future, the plaintiff must return to court in order to receive additional damages. Thus, temporary damages impose high transaction costs for dispute resolution. With temporary damages, reductions in future harms translate directly into reduction in liability. Consequently, temporary damages create incentives for insurers to continually adopt technical improvements that reduce external costs. With permanent damages, the plaintiff receives compensation for past harms plus the present discounted value of all reasonably anticipated future harms. Superscript 59, it reads, see the section on asset pricing in Chapter 2 for more on discounting. Back to the text. One lump sum payment extinguishes claims for past and future harms at the level specified in the judgment. Unfortunately, future changes in technology and prices are difficult to predict, so the estimation of future harms suffers from error. Thus, permanent damages impose higher error costs. Furthermore, by paying permanent damages, the injurer purchases the right to external harm up to the amount stipulated in the judgment. Consequently, permanent changes create no incentive for insurers to adopt technical improvements that reduce external costs below the level stipulated in the judgment. Superscript 60, it reads, in his dissent in Boomer versus Atlantic Cement Company, which we discuss next, Justice Jason recognized this point in his criticism of the majority's award of permanent damages. He wrote, furthermore, once permanent damages are assessed and paid, the incentive to alleviate the wrong would be eliminated, thereby continuing air pollution in an area without abatement. Back to the text. As explained, temporary damages impose high transaction costs, whereas permanent damages impose high error costs and undermine incentives for reducing future harms. Transaction costs of resolving disputes, whether by trial or settlement, are low when liability is certain and damages are easily measured. Error costs are high when innovation improves abatement technology and changes the understanding of the harms caused by externalities. Thus, temporary damages tend to be more efficient given easily measured damages and rapid innovation. Conversely, permanent damages tend to be more efficient given costly measurement of damages and slow innovation. We commend damages as the remedy for a public nuisance. However, common law has not traditionally followed this prescription. When the public is harmed by a nuisance, courts traditionally allow the affected parties to enjoin it. The following case suggests that the common law has become more receptive to damage remedies for public nuisances. Read the case, bearing in mind the difference between the traditional remedy for a nuisance, damages for past harm, and an injunction against future harm, recurring damages, and permanent damages. After reading the case, test your knowledge of externality theory by answering the questions. The questions are: question 5.31, is the externality in Boomer private or public? Question 5.32, Are the transaction costs of bargaining among the parties low or high? Question 5.33. Suppose that households had a right to enjoin the cement company to stop polluting. What obstacles would the cement company face if it tried to purchase the right to pollute from the households? Question 5.34. Explain the remedy given by the court. Suppose that at some time in the future, the cement company doubles its rate of output, thus increasing the noise, smoke, dust, and vibration inflicted on the neighbors. Do the homeowners have a remedy? Question 5.35. Contrast the difference between temporary and permanent damages on the incentives of people to build new houses near the cement factory. Question 5.36. To what extent can the private law of property solve the problem of pollution? Webnote 5.8. See our website for an additional case and some additional questions on using nuisance law to correct externalities. We also summarize there some new literature on the choice between property and liability rules as remedies.